Welcome to the Bullhorn Betty Coffee Club.
As you wake up in the morning, you want to find the latest, greatest information about criminal cases and have an intuitive conversation about the suspects associated with these cases. Head over to the Bullhorn Betty channel on YouTube. Get breaking news right here on the Bullhorn Betty channel. Welcome to the Bullhorn Betty Coffee Club. Enjoy your stay and enjoy your day.
Well, good morning, coffee crew. I love seeing you all here this morning. I know we're getting started a little late today, but that's because we have trial, and these trials we're getting to the end. We're getting to the end. The good news is today in the Letecia Stauch trial, they're going to be resting their case. The state is resting their case. They're going to be coming in this morning, resting their case. The judge is most likely going to be asking Letecia if she's going to take the stand in her own defense. So I believe today we are going to find out that information. Is she going to take the stand? I called it wrong. Alec Murdaugh, many of you guys know. I said he's not stupid enough to take the stand, and the man was stupid enough to take the stand. So good morning, everybody that's tuning in. Many of you guys were here an hour and a half before we started this morning. So God bless you. The first in line to say God bless you, the Van Lady. Nice to see you. Followed by ZA, Southern Granny Wolf, and Sonia. You guys rock. And you guys are just having a good old time in the chat this morning. I see. And then Jennifer L., good morning. It's nice to see you. She is the beautiful soul. And she sent this just to let everybody know. She sent this on behalf of everybody, all the coffee beans. Yesterday, you guys heard a knock at the door. It wasn't a secret Santa. It wasn't a secret admirer. It was the coffee club with Bed, Bath, and Body Works. And I got to tell you, this warm vanilla sugar is OMG. You know what? As a matter of fact, I didn't spritz this morning. I did take a shower, so I smell good, but I didn't spritz. Guess what? I smell amazing. I smell amazing. Love it. Thank you guys so very much. Love it, love it, love it. Robert's girl got me this beautiful, if you guys weren't here, this beautiful picnic blanket, which is good for when we're out. We just need to sit down on something clean. And I can't remember who it was. Let me see if I got it right here. Valerie sent me the laminating sheets. They're full size laminating sheets for 8.5 by 11 pages, which is amazing because that means we can do more. What we've been running into is, we put up these signs for missing people. Well, the next rain or storm that rolls through, those flyers are ruined. So when I go into a community, having about 10 laminated flyers that we put up for that person really does make a difference. We know it'll be there and it'll be protected. So God bless you guys for all of that. Thank you. Thank you. Gigi for life. It's nice to see you in the house. And I see Linda Lou. Linda Lou, I see you. Kathy S. was chatty Kathy this morning. Nice to see you. And Macrotus, I don't know if I'm saying it right. You gotta tell me. It's driving me nuts. I don't know if I'm saying it. I hate people saying names wrong because my name is unique, right? It's Andra. It's not Andrea. It's not Andra. It's Andra. Like Sandra without the S, right? So it's like, and I see it's A-N-D-R-A. You'd think if somebody pronounced it out, they would be able to figure out that it's not Andra, it's Andra. But I digress. So whenever I see people's names that stump me, I feel so bad when I call them the wrong name, because I have literally been called the wrong name my entire life, including when my parents were very, very angry at me and my sister. And instead of calling me Andra or calling my sister Angela, it came out, Angela, get your butts down here, right? So I'm sorry for butchering your name. So sorry. But it's nice to see you here this morning. Miss Margaret is in the house. It's nice to see you. Struggle is real. We had a lot of people chatting it up this morning. The real me too. It's nice to see you. Unicorn, it's nice to see you as well. And I saw Okie Cranky Pants. I saw you. Okie Crime News is in the house. I saw her this morning. It's nice to see you guys. Ollie, AJ, good morning. Suzanne, Misty, it's nice to see you as well. Pebbles, getting in the room late. I even started late for you. I'm just joking. I'm just joking, Pebbles. Just showing some love. And everybody else that came, Amanda, Patricia, Mama Llama, there you are. You guys are all waking up now that I'm getting down to 9:30. MJ, it's nice to see you. Midnight Nurse Carla, nice to see you. Chadwell is in the house today. Good morning, Chadwell. Who else do we have that I have glossed over? If I glossed you over, you matter to me. I just wanted to say good morning. Dixie, Kentucky girl, Candy Apple. Wow, it's nice to see you, honey. Alabama Mama of 4. Good morning. Nice to see you as well. Patricia, I think I said good morning to you, but if I didn't, I just saw your name again. So good morning to you. Angie, good morning to you. Emma M, nice to see you. There you are, Okie. I saw you in here earlier. TCC, so, nice to see you, Dumpling. Good morning. I didn't get a chance to see your video. I got to pop in for a little bit. I got to go back and be part of the replay crew on Dolly Vision. I heard you collab with Dolly, so congrats. I hope to get to see you soon. I just didn't have an opportunity, but I'm done with this trial. I have to tell you, I am wiped. I am so done. Put a fork in me. I am done. Net L, it's nice to see you in here. Angie, I think I said hi to you, but if I didn't, good morning. Just Samantha, Twin Mom T, nice to see you as well. Wanda, good morning, beautiful lady. It's nice to see you. Buck Cherry Lover, nice to see you as well. Deborah Ferris, good morning. It's nice to see you in the house. Guidance, good morning, love. Me and you got to get together. You're so close and we never see each other. So I'm going to end up having to take you to lunch one of these days or something just to catch up. So get in touch with me. Let's plan something. I'm leaving just to let you know, I'm not sure what we're going to do, but I have made plans. So we are going on the road very soon. We're going on the road very soon. And I think we're going to go a little kind of non-mainstream on some couple news articles. So this is going to be a little exciting. We'll see if we keep the audience attention, but we're going to go on the road, see some landscape, right? Some landscape. I'm going to do like a 2 or 3 state tour. It's going to be kind of Midwest. We're not going to Idaho. But, and I'm still waiting to decide. I may end up getting a red eye out of here on May 24th to be a part of the May 25th hearing. It just really, really depends. We'll see. Otherwise, we may just have to wait until the preliminary hearing to get there. But I'm monitoring it and managing it as we speak. But anyways, it's nice to see you, Wanda, Lady 7 Up. It's nice to see you. Mike Stevens finally gets his butt out of bed. Whatever is in the house, sort of the spirit. Nice to see you. I think I said hi to you, Ollie, but I'm not sure if I didn't. If I missed you, good morning. Jazz King, M.E., it's nice to see you all here this morning. Roxy, good morning, love. Good morning. So we actually made it through everybody. It only took us 10 minutes. But we got a lot of stuff to go over that's going to keep us occupied until the trial starts today. But we are expecting immediately upon the trial starting, the state resting its case. And we're going to start. I don't know if they're going to be giving jury instructions just yet. I think they assign the jury instructions to the attorneys to formulate and to turn over to him for him to make any other type of modifications to it. So I don't know if they're doing the jury instructions yet, but from my understanding is we're way ahead of schedule in this case, that the state, was able to get moved through, because I think they were expecting a lot more of the stuff they were entering to be challenged by the defense. However, the issue here is the defense really wasn't disputing a whole lot of information. They're not disputing that she killed this kid. She's admitted to killing this kid. They're not really disputing any of that. They're trying to, they were really honing in on the mental aspect. They really kind of dogged it whenever the forensic psychologists and everything were on the stand. They were getting a little rude. They were getting a little hot under the collar. We saw it ourselves. Stroud Monroe County, human remains found in wooded area have been identified as Dana Smithers, who was reported missing. As a matter of fact, I'm glad you brought that up. Sort of the spirit that is on the itinerary for this morning before the trial starts. We actually have that pulled up and we'll be going over it. And people want to know the importance of it. Is it possible that this could have been a victim of Brian Kohberger's? And the answer is absolutely is. It absolutely is, depending on her. Obviously, it's been a significant amount of time before they found her, but these remains have been identified as Dana. And she disappeared like May 2022. So I actually have some really important information that we're going to be pulling up. So thank you, Sort of the Spirit. It is on the itinerary for this morning to discuss. So Ollie, thank you. God bless you. That's so sweet. Thanks. Oki, he was a sex offender married to a woman that had 3 children, and a stepdaughter had 2 girls that went missing. Over all 7 were found dead. That is absolutely correct. This is also on the itinerary. We're going to get to this very soon this morning. So let me go ahead and start moving along with the language of letting go before we start getting in all the nasty this world has to offer. We want to empower people and align internally. And so that's providing inspiring messages to people in my audience that may be struggling, whether they're vocally struggling or they're struggling in silence. So we use the language of letting go, which is really for codependent people. But I find a lot of goodness and a lot of talking points that can come out of this particular book. But it has been a lifesaver for me. And I know if I get something out of it each and every day, there's somebody in my audience that's going to get something out of it. So May 2nd, which is today, the title of this segment in the language of letting go is Say When It's Enough. Really good topic. Say when it's enough. I think we can all identify with we've had it up to here moments in our lives, right? Where we just say we can't take no more. Why are we doing this to ourselves? Let it go. We're done. When, I call it tapping out. If you know me for very long, what I say is I'm tapping out. I tapped out, or I wash my hands of you. That's my when I've had enough. That's when I've had enough, right? So this is one. It says, say when. My friend says she refills my glass, meaning she wants me to tell her when I've had enough juice. Say when is a simple idea that we can use in our daily lives as well. Sometimes there is no visible end to our troubles that beset us, and all we can do is seek shelter from the storm. But often it is up to us to decide when we have had enough. An irritant might just be a minor inconvenience for a while, but the longer it lingers, the more irritating it becomes. Say when. Say that you have had enough and refuse to let the irritant into your life anymore. A draining person can latch on a sympathetic ear. Know when that person is starting to take more than you're willing to give. Say when. The same can be true of a good thing. Some of my friends, they take 5, 7, even 10 or more skydives in a single day. I don't. I love the sport. But I also know when it becomes too much of a good thing. For me, I say win. Be aware of how much your cup can hold. When you have had enough, say win. God help me know and respect my limits. So I thought that was a really good messaging. This can be applied in every aspect of our life, from a relationship with our children to a significant other to an employee type of relationship. This can literally be applied anywhere. I think we are trained as human beings to be giving in nature, care for other people's feelings and things of that nature. Sometimes I feel we take so much of ourselves and give to other people until there's nothing left. And I think it's good for my audience to know when to say win. And also learn the power of no. You don't have to be the hero for everyone. You need to save yourself before you can save someone else. And that's what we're doing. That's what we're doing. We're no good in helping other people if we're feeling garbage and crap inside our own selves, right? So we've got to fix that before we can do better. Now, getting on with this, we've had a lot of really crazy stuff going on this week, from the Mexican national shooting up that family for asking him to quit shooting his gun, to now this whole family of 7 people being found deceased in Oklahoma, in rural Oklahoma. Just a lot of stuff is going on. And then of course, we have Dana Smithers, that disappeared in 2022 and has now been found, and her remains have now been confirmed to be Dana Smithers. And we don't really have a whole lot of information other than that. Was she shot? Was she stabbed? Did she die from medical events? Because it sounds like she left her house willingly and just never returned. So I'm interested in finding out the details in and around her. This may not be anything significant, but the timing is awful suspect. And we're going to go over why it is so suspect. There we go. So we're also going over to we're going to go right over to that case right now, and then we'll dovetail back to Dana Smithers, and then go into Letecia Stauch's trial. So that's kind of the setup for today. Jason, it's nice to see you. They think the guy is a serial killer. Oh, he's definitely a serial killer. We just don't know to what degree he is, because serial killers still have to start with their first kill. And it is believed by many, or really, I shouldn't say believed, hoped, I think is the word that we're looking for, hoped by many, that the Idaho 4 truly was his first. We don't know if that's the case, but definitely the mindset and everything else of a serial killer, absolutely, Jason, without a doubt, hands down, that is a good description of who Brian Kohberger is, at least in my mind. So I'm going to go ahead and get on over to a couple of little videos that we're going to be watching, and then we'll open up the phone lines before we move on. You're going to have to hear an advertisement, a commercial, before it goes into the story.
See for the world's most powerful navy. I don't feel like I have to shrink myself here.
We are no longer looking. We believe to have found everything that we were seeking this morning. Approximately at 1500 hours, we arrived out here with a search warrant.
That warrant, executed on a rural property there, brought a gruesome discovery.
We've searched the property and we've located 7 bodies that we are in the process of trying to get the ME to be able to confirm identities of these individuals that were found.
They'd been looking for 2 teenage girls, 14-year-old Ivy Webster and 16-year-old Brittany Brewer.
So that's.
Please welcome an absolutely new Crossout, a free-to-play multiplayer action game about battles.
Sorry about that. So now we're going to go over to the other portion here, which is the officials say 7 bodies found in the search area. This is in Henrietta. Sorry, it's my internet sticking just a little bit. Henrietta, Oklahoma. A missing, at-risk, and danger alert for 2 missing Henrietta teens was set out on Monday morning by Oklahoma Patrol. The alert has led to the discovery of 7 bodies in Okmulgee County. It is believed to be the bodies of the teens have been located, but the medical examiner is working to identify the identities. 14-year-old Ivy Weber, which is this girl right here. Brittany Brewer was thought to be with Jessica McFadden. So there you go. There's Brittany Brewer. Around 3 p.m., a search warrant was executed on the McFadden property and the bodies were found. The sheriff says no other threat to the community and they have called off the search for the teens. He also said his heart goes out to the family and friends of the one. So here, let's go ahead.
Is alive in Henrietta.
Let's just go back. So there we have it, folks. There's the update on that horrific case out in Oklahoma. And this comes down to people. You've got to start paying attention to who you are bringing home with you. This is a man that wasn't biologically related to any person that was deceased. Okay. And you're talking about him, his wife. His wife is deceased. I guarantee that she's going to be one of the bodies. She had 3 stepchildren. She had 3 children, his 3 stepchildren. So those are presumed to be there. So that's a family of 5, right? 2 adults, 3 kids. And then you got 2 friends of one of the stepchildren over there. That's 7 bodies. That right there is who the victims are. And again, this Jesse McFadden, a convicted RSO, going to court today for rape of another person. And I think it was one of a minor to boot. And the whole entire family and 2 friends are completely wiped off the face of the earth. And this is a man that did not have biological relationships with any person there. This is someone mama brought home. Okay. I know some people are going to probably be offended by me saying that. And that's okay. That's okay. But, mama brought this monster into this family. That's who did this. And it's not I don't want to victim shame the mom at all. But this is not, and it's not her fault that this happened. But this is where doing due diligence on somebody you're seeing. Jesse is one of the dead. Yes, Jason, that is correct. But you have to start taking notice who you're bringing home. This is a person that exposed their young children to a monster. And I'm sure it was unbeknownst to her. There's no good woman out there that would be willing to put her children in harm's way. So I don't think this was intentional, but we don't know. Did this guy become abusive to her? Did she not leave? Was she leaving? Did he realize that today would seal his fate and his family was done? I mean, I don't get, maybe the mindset, if I can't have you, nobody can. I'm not sure. But we definitely know that this Jesse McFadden was not biologically related to anybody in that home. However, he was married to mom. So it's just a sad, sad case. So, and we have a lot of this. There's another lady in Ruskin that's in jail right now for killing a kid, shaking a kid that she was watching. We talked about another lady recently that, a studious-looking young lady that is in jail for killing a kid watching the child as in a babysitter role. So it's not just the babysitters; it's who we are seeing, who we are bringing home, who are we exposing our children to. They are married. So obviously they had courtship. They've lived together. Who knows what happened? Who knows what the relationship is inside that home? Who knows whether he was with one of the teenage girls that ended up getting deceased? Maybe they were one of the people that had a case against him, for all we know. We don't know. We have literally no information to even theorize at this point, other than we know he's a convicted sex predator. And 2 young girls went missing, and in the search of those 2 young girls, those underage girls, it got law enforcement to a property where they found those 2 girls deceased, along with 5 other bodies. So that's really all we have, all I really have to say about the Oklahoma 7. I will keep my audience updated. This is a serious case. I would like to know some more information. And from the Bullhorn Betty channel, from all of us, we need to make sure that we're keeping this family and their schoolmates. These kids were going to school. Kids don't understand this stuff. So we need to keep their schoolmates as well as their family and friends in our prayers. I saw a video from the father of one of the Brewster Brewer girl, and you could see he was just devastated, absolutely devastated. But his heart was warmed by the beauty of everybody coming out in support of his daughter and her friend. So it was just very hard to watch. You know, hearing some of this stuff is very, very hard to digest and watch. But either way, you know, this was just senseless. This was just senseless. So getting on with other news, right? The Idaho 4. We're going to be discussing that. There's some new information coming out. I'm sure there's a lot of people on the internet that broke yesterday. You know, we knew that we heard there was going to be a hearing for Bryan Kohberger from May 25th, 2023. And we were all, you know, wondering what that was all about. So I noticed that Sleuthy Goosey had dropped some information about it. And so I just happened to drop my theory of what, you know, I thought maybe it was possible that the media decided to go to the lower court per the opinion from the Supreme Court. You know, it sounded like, you know, the Supreme Court acknowledged that they had standing. So the 2 prongs that needed to be provided to the Supreme Court so they could, so they had jurisdiction over the case. It wasn't that they didn't have standing. That means they didn't have, you know, they didn't have the rights to bring this case. They absolutely had every right to bring this case. What they were saying is that they didn't meet the 2-prong test for jurisdiction. So they needed to have you know, prove that they had standing, and they also needed to confirm that the Supreme Court had jurisdiction in the matter. And that's where they failed, because in a situation where there's an urgent case, they can jump over a few steps and go straight to the Supreme Court in an urgent matter. However, the Supreme Court is basically saying that, no, this is really not an urgent matter. You could have redressed this at the lower court, let them rule on it, and then appeal. And so when I was talking or you know, having this little Twitter conversation with Sleuthy Goosey, she let me know that that she knew some of the media folks that filed that first action with the Supreme Court, and they basically had told her they weren't planning on addressing it in the lower court. And so, you know, we were still, you know, and she didn't know if that would bring, you know, Bryan Kohberger, you know, have to appear in person or whatnot. So I was thinking it was either, you know, they were going to be adjusting or modifying the non-dissemination agreement, or it was going to be to discuss the Brady issue that was filed from the state in the case of Bryan Kohberger. But what we're learning today is, and I had completely forgot about the ruling of the judge back when the Gonzalez family filed their motion into the court asking them to modify the non-dissemination order. And the ruling of that was she wasn't going to rule on it until the Supreme Court ruled on their case. Well, the Supreme Court did rule on their case. They basically said that they would be willing to take the case if the plaintiff can prove the items in there. And if they can prove the items in there, they absolutely have standing. And even in this thing, let me just read, I went through it this morning and I wanted to read some excerpts out of this opinion from the Supreme Court. And we're going to start on page 6 of it, because that's kind of where the analysis of this case really comes in. It's at the bottom of 6, but doesn't really start until you get to the top of 7. But he goes on to explain that in order to establish standing, a plaintiff must show an injury in fact, a sufficient causal connection between the injury and the conduct complained of, and the likelihood that the injury will be redressed by a favorable decision. And according to the Supreme Court, the plaintiffs in this matter, which is the Associated Press or the petitioners in this matter, the Associated Press and the 31 collective media organizations, according to the Supreme Court, did meet that standing. And they further state that they maintain that the amended non-dissemination order hinders their ability to gather such information. If the petitioner's allegations are true, which we know that they're true, they have alleged an injury that is concrete, particularized, and actual or imminent, not conjecture or hypothetical. So they're saying if they can prove this, then yes, they've got a grievance here. Additionally, it states that if the amended non-dissemination order is vague, overbroad, unduly restrictive, or not narrowly drawn, it would be unconstitutional obstacle to gather such information, which we know that the current non-dissemination order rises to that level. It is an obstacle to media gathering such information that is given to them under the Constitution. It further states here that the amended non-dissemination order broadly, and this is one of the things, remember, it just said it in its sentence above, additionally, if the amended non-dissemination order is vague or overbroad, unduly restrictive, or not narrowly drawn, it's overbroad, it's any and all. That's overly broad in the sense of court. Then it's unconstitutional. She's saying it would be unconstitutional, and then goes into explain this non-dissemination order and states here the amended non-dissemination order broadly states that those prohibited from commenting includes but not limited to, and they're citing that language, the includes but not limited to, as overly broad in accordance to this opinion from the Supreme Court. So let me read this again. Here, the amended non-dissemination order broadly states that those prohibited from commenting on the case includes all, but is not limited to, individuals from a list specified categories. The order also restricts such individuals from commenting on anything concerning the case. So he's citing that this language, order restricting such individuals from commenting on anything concerning the case, they're citing as overly broad. Aside from items such as official public records of the case, again, very overly broad. While the wording of the order appears to apply to both attorneys and a broad array of individuals, a contrasting, so they're saying that even though this order is saying one thing, there's a contrasting statements provided by the judge in this meeting that we're about to get to, contrasting in a memorandum that suggests the court is not ordering clients or witnesses not to talk to media, and that the judge reiterates she's not saying the clients can't talk to media. But she's not realizing she can say that in a memorandum, but her order states otherwise. And it further states, based on the records, we conclude that for the purposes of establishing standing, petitioners, that is the media, have sufficiently alleged an injury in form of their diminished ability to receive speech and effectively gather news. Further, the media's concern that the order provisions are vague, overbroad, unduly restricted, and not narrowly drawn are not merely contrived, and if established, could improperly infringe on the press's constitutional right to report the case. This was not a good order from the Supreme Court for Judge Megan Marshall, and that's what I'm trying to allude to here. Is that I expect her now that she put the Gonzalez, motion to amend the non-dissemination order and having this very particular opinion from the Supreme Court in Idaho. This is not boding well for Megan Marshall, Judge Megan Marshall. She's going to have to adjust this non-dissemination order, because even the Supreme Court is saying that if all these facts are true, which we know they are true, then it is unconstitutional. And that's what I've been saying from the very beginning. They're not going to be able to rise this. They're not going to have legal muster to go after this. And I think the reason why media is not going to the lower court, because there's already a motion in the lower court by the Gonzalez family in which they can appeal should they not get what they are seeking from Judge Marshall. Now, if Judge Marshall wants to adjust her non-dissemination order so it's constitutional instead of unconstitutional, that would be the best move for this judge. Because what will end up happening is the Gonzalez family, I truly believe, are prepared to fight this, especially in light of the Supreme Court ruling or opinion. I'm pretty sure they're going to be ready to move it on up and go for the appeals should Judge Marshall not budge, because she is violating the constitutional rights of not only the Gonzalez family, but also every piece of media organizations and social media organizations that are following this case. She's violating all those rights in an effort to not violate one person's rights. You cannot do that. You've got to be able to balance everybody's rights. You can't hinder somebody's. It's a balancing act. This is why judges are voted in, because people want judges that know what they are doing. This judge seems to be overwhelmed and not seem to know how to preside over this case, this particular high-profile case. She seems to be struggling with that at this moment. Accordingly, and is this the last statement I have? Yeah, this is the last little excerpt that I wanted to bring to your attention. And it says, accordingly, if the petitioners want relief or clarification of the amended non-dissemination order, the proper course is to first seek redress from the magistrate court, which issued the amended order. So now we know that is where the Gonzalez family filed this. That is where they are going to be able to fight this. This is the steps that even the Supreme Court themselves are saying to take. So it says, first seek redress from the magistrate court, which issued the amended order. If the media is still aggrieved after seeking such clarification or an amendment to the existing order, then they have the avenue of appeal. So the Gonzalez family is fighting this. This is a motion that the Gonzalez family brought forth, and this is what's going to be argued on the 25th to see if there's any movement on the non-dissemination order in the Letecia County related to the Brian Kohberger case. And if there's not, according to the Supreme Court opinion, the Gonzalez can then file an appeal and take it back to the Supreme Court, where they will have proper jurisdiction over the matter and can rule on it at that time. I'm hoping that Megan Marshall, Judge Marshall, does the right thing. But, again, this is something where the judge just seems to be a little out of her element and not quite doesn't quite know how to deal with these issues. Some seasoned judges, they've been dealing with it for a long time, not the first time that they had a high profile case in their court. They have a great management skill of it. This might be very new. I mean, we're talking about Letecia County. We're talking about Musco, Idaho. There's not a whole lot of people. So I doubt that they've ever had, or at least have had a case like this in a very, very long time. And it seems to me that Megan Marshall is a fairly young judge. So it wouldn't be out of the realm to think that maybe she hasn't presided over a case like this in her history. So we'll just see. I do believe that this will all work its way out. That I truly do believe. I believe that. Give me just a second. I just wanted to make sure it was up so we don't miss anything since we're starting. We're in the half an hour before we start the trial. So I wanted to make sure it was up so we didn't miss anything. But I think the judge is going to modify her order. That's my opinion. I think it's going to be difficult for her at this point in time. I don't care whether the state or the defense agrees or stipulates to these types of orders. What if they're unconstitutional? They're unconstitutional. No stipulation can stipulate your way out of an unconstitutional order except to bring it back into an order that is constitutional under the state of Idaho as well as the United States Constitution. So I have a funny feeling there is going to be modifications and clarifications. She might get so specific in her next order that it's going to be, it's going to be very, but we need to start opening up. Like, everybody shouldn't be shut down on a case like the Idaho 4. I've never seen anything like it where we can't get public records requests fulfilled that literally have nothing to do with this case, most likely will never be brought in this case, but because it's associated with the home, associated with Brian Kohberger, associated with one of the victims, we are being refrained from getting that stuff that has nothing to do with this case. So because it has their names on it, they can't do that. They can't do that. And I've been saying that since this stuff started going on, and everybody is so happy that they did, the hate channels are so happy that they didn't even bother reading the opinion. They're just like, oh, they denied it, ha ha ha, right? Well, here we go. Now Megan has to deal with it herself. She's going to have to deal with it at her court. She's going to have to deal with it under the law. So before we get started, that's really all I have. I think that's all I have. I feel like there's something else. Hold on a second. Oh, yes, there is something else. Hold on. Let me share this and then we'll get back to that tab. So here is the original order about the Gonzalez. There we go. About the Gonzalez hearing on the motion to appeal amended and or clarify amended non-dissemination order. So their attorneys was going through the right procedures and taking this to the magistrate court to rehear this information, but she didn't rule on this because media went ahead and got the appeals court involved. So she deferred ruling until the opinion came out from the Supreme Court. And here it is, a motion to appeal, amend, or clarify. And this again was on Sleuthy Goosey's Twitter feed. So a motion to appeal, amend, and or clarify amended non-dissemination order, motion to appeal, and memorandum in support of motion for appeal and or clarification of amended non-dissemination order were filed by counsel for the Gonzalez family on February 3rd, 2023. It further states this matter before the Idaho Supreme Court docket number 50482-2023 directly relates to the amended non-dissemination order for which counsel for the Gonzalez seeks to appeal and amend. Hold on. Sorry. To amend or clarify. And it says, please take notice that oral arguments on the motion to appeal, amend, and or clarify amended non-dissemination order will be scheduled and notice provided to counsel upon the issuance of the Idaho Supreme Court's decision in the Associated Press et al. Versus Second Judicial District of the State of Idaho, County Letecia, Honorable Megan Marshall, Magistrate Judge, docket 50482-2023. So there is the order. Again, thank you, Sleuthy Goosey, for finding that and highlighting the necessary portions for people to disseminate to their audience. So there's where this hearing is coming from for those that are curious. So that is pretty much what I have for this case. So what I'm going to do now is I'm going to go ahead, give me just a second. I'm going to go ahead and open up the phone lines just for a little bit. We have about 22 minutes where people can call in if they so choose to discuss their feelings on the Oklahoma 7, the Idaho 4, or any other case that we are reviewing and monitoring at this time. You know, we heard some really horrific stuff coming out from Oakley Snow's case, and we never quite got through the probable cause affidavit. It was really hard to actually, up to that point, it was fine. It wasn't too difficult to get through. But as we're starting to get into more details of that case and what's in that affidavit, it's going to be harder and harder to follow, because she was brutalized. That little poor baby, not even 2 years old, was just brutalized. And it was because the mom is on drugs. The mom is on drugs. So it's just this senseless stuff that we have to watch and witness is just horrific. Any case you'd like, yeah. And also for my audience, in your communities, if you see cases, unsolved cases, if you see a missing person coming out in your area, please email me. Email me the details of the case. If you have the link, like if it's like your local news organization that's covering the case, add that into the email. Get the URL and cut and paste it into the email so I can see what you're referring to. It'll help me get a starting point in my investigation. But always, 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 if you're asking me to look into the case, consider putting the victim's name, any information you have. If you have date of birth for the victims or the assailants, put that information in there. If it's a missing person and the family needs help, put their phone number in there. But whatever you need to do, go ahead and send that to me. But the more information you can provide me, the more I'll be able to look into it. Because if I have somebody sending me a case that has a lot of information to it, I'm most likely going to review that case first, because I already have a lot of information. That's less stuff that I have to look up myself, less work I have to put into that case up front. And it's more research that I can start providing that particular case and figuring out what record request needs to be requested and things of that nature. So at any rate, that is what I'd like from the audience as you're asking me to look into cases. Some people just send me a first name, and it's like, there's a lot that goes into that. It's not just the first name. We need to have as much. If you know more about a case, put a dissertation in there. I mean, even if you don't like typing, type something out. Give me some direction to go through or go in. If you know anybody or have any insight, private insight, even if it's confidential, put a portion down there that says confidential. Then I know I can't share that information, but any information that can help me acquire more information about the case would be greatly appreciated. Let me just check and see if we're missing anything in. Okay, nothing there. Let's see what we got going on in the mod squad. Oh, Pebbles, you're cute. Yeah, and it's kind of funny because I heard that fireworks were going off a little yesterday. I heard Jody Sue and Don Wells had a big powwow. I don't know if that was yesterday or the day before, but I'm seeing it's making its rounds around YouTube today. Jennifer Cass says the police just solved a case from 40 years ago. All 3 suspects have since passed. It's suspected to us that one of our family members was involved, but police won't release names. Oh, wow. Wow, 40 years ago. That took a long case. There's so much, people don't realize there's so much advancement in technology that we have nowadays that we didn't have back in the days. And back in the days, we had some of the highest, people that were in jail innocently put behind bars. And a lot of that affected a lot of the black, back in the day, believe it or not, it affected the black population because there for a long time. All white people had to do was point at the black person and say they did it, and they would go after them, then stack the case against them. So we don't want to acknowledge the ugly of our history, but it is true. It is true. There are a lot of people that are behind bars for some gruesome crimes that they never committed. That's why I like the technology now. Like, we have some of the best advanced technology for crime fighting, and it's upsetting when people get away with murder and some of the horrible acts that we hear people get away with. I mean, there's no excuse for that. There truly is no excuse. Like, we're in 2023. We have given up every ounce of privacy known to man here in this country, where we literally have a constitution that provides us the right to privacy. That's how crazy it has gotten. They follow us from from our cars. They follow us from our phones. They follow us from our credit. And think about who all instilled this. Our government. This was a cash country. Who started forcing us to use credit cards? Who? The government. So they track us by our purchases. They track us by the vehicles that they're requiring to track us. Do you think you can go up to Kia and say, hey, I don't want the tracking device. I don't want the black box in my car. No, you're purchasing the car with that in it. So they can track you with your finances. They can track you with your car. Cell phones was historically completely expensive to have. But the government has helped lower the cost of our phones. So now our phones track us. Then they start putting up cameras, right? Cameras at our intersection to monitor the traffic flow. Well, now, not only do they have cameras to monitor the tracking flow, they have readers, license plate readers, to make sure that they're tracking us wherever we're moving inside of the United States. Our ability to have our privacy has rotten away to the point that everything that we own spies on us. And that is the reality of life in the United States, and most likely a lot of places around the country, around the globe. And it's true. So you're not getting away with murder. We've got so much advancement in technology, DNA, all this spy stuff, from each city, state, and county across this country. There's literally no good excuse for people to be getting away with murder and getting away with horrendous crimes. There's just no reason. The rest of us, law-abiding citizens, have stripped ourselves of our ability to have our privacy. So these types of things don't happen. And guess what? They're still happening. They're still happening. We're not seeing terrorists, the reason why we gave our rights away, the Patriot Act. We're not seeing terrorists dealing with the laws of the Patriot Act. Law-abiding citizens are the ones that are having to deal with the laws of the Patriot Act. So, but you know what? There's no good excuse for people to be murdered and cases not to be solved. So the people need to start thinking outside of the box, because we are tracked everywhere. Literally tracked everywhere. We're like cattle. The only thing we're missing is our number pinned to our ear. That's it. All right, 13 minutes before the start. If anybody would like to call in, you can. The phones are open. And to give you guys a little bit of an update on that person that shot up the house, the Francisco Oropesa, he still, from my understanding, has not been found yet. I'm looking at some of the news that we have for him, and it doesn't look like he's found. They have over 200 law enforcement members searching for him, and I'm pretty sure that has expanded quite a bit since he's on the run. He's done this heinous crime, including the killing of an 8-year-old a child. According to Mr. Garcia, a few minutes after they spoke to Mr. Oropesa. So Mr. Oropesa allegedly entered his neighbor's home armed with an assault-style rifle Friday evening after his neighbor, Wilson Garcia, asked him to stop shooting his gun in the backyard because it was keeping Mr. Garcia's baby awake. According to Mr. Garcia, a few minutes after they spoke, Mr. Oropesa walked over to the home and opened fire, killing 5 people. Sonia, and I reread this yesterday, Sonia Guzman, 25, her 9-year-old son, Daniel Enrique Lasso, Diana Vasquez Alvarado, Julissa Riviera, and Jose Cesares. According to the report, all 5 victims were from Honduras, though Miss Vasquez Alvarado's husband said his wife was a permanent resident of the United States. Now, the town of Cleveland, Texas is mourning authorities while authorities are trying to locate the shooter, Francisco Oropesa, if I'm saying the name correctly. All right, guys, this is your 10-minute mark. 10-minute mark. If you guys have not gotten your coffee, have not gotten something to snack on, we are going to be rolling into the trial here in the next 9, 10 or so minutes. What else? Oh, don't forget, the way it's going to work is I anticipate the jury coming in, the judge saying, hey, is there any reason why you can't, act as a fair or impartial jury? Is there anything that has happened in the last 24 hours that, whatever this, that, or the other may be? They're going to say no. He's going to open it up, and then the state is going to immediately be resting their case. And then the defense is going to be calling its first witness. I don't anticipate the defense to have a whole lot of witnesses. I think at this point, in my professional opinion, Letecia is done. She's not going to overcome this. There's not going to be any information that the defense is going to be able to display to change the minds of these jurors that this woman committed this crime and she was not insane up to the level that is required by Colorado, where she has to be so defected by her mental illness that she doesn't know right from wrong. And that is going to be the burden she's going to have a hard time overcoming, is the fact that she knew right from wrong. And yesterday, their last witness was able to pull all the information they heard from this trial from the prosecutions from the state side, and they were able to put it in a nice clean bow as their final witness walked them down the timeline, showing them everything that happened and all the text messages and all the responses and the movement of the cars and exactly what was going on in and around that time. They were walking them through everything they heard in trial, bringing all that information together, making it easy to understand. And we are very thankful for that, because it was, the defense went to question the witness on the stand, and he didn't really ask a whole lot. And then he's like, no. So they asked the state if they wanted to recross, and they said, we don't need to, or something to that effect. It was funny. It was like, it was the final drop the mic, moment for the state in the Letecia Stauch trial, where they're like, we're done with this witness, man. The witness did great. Like, we got nothing more for this witness. We got nothing more that we want the jurors to hear. Like, we're done with our case. We proved our case. And I am confident that they did just that. I think the state really did prove this case, and God bless Gannon's family and friends for this horrific tragedy that they had to go and deal with. And then to have this woman adding insult to injury by calling Gannon's mother a C word and taking his father hours upon hours down these rabbit holes of just, I don't know how Al Stauch did it, but he is one of the strongest men I have seen in a really long time. And he took it. And he listened to every single wild story Letecia told him. And all he wanted to do was just find his son, bring his son home. That's what he wanted to do. That's all he wanted to do, was find his son and bring his son home. So hopefully they will be able to do that. Let me just make sure that we are getting ready. I just want to make sure, because I noticed I'm having some lag on my end here with this internet, and I'm not sure what it's for. So I'm just going to break before this gets started. Oh shit, I didn't mean to do that. Before this gets started, I'm going to go ahead and refresh this stream. I'll be right back. So just bear with me while I refresh everything. Actually, let me do this. All right, I think we're good. Give me just a minute. And let me pull this other. Oh, we're getting started right now. I just saw the camera come up, guys.
People versus Letecia Stauch. Record should reflect the jury's not present in the courtroom. Yesterday, when we took our break, Ms. Gratiano had gone through all of the exhibits. There were 5 that there were questions about. It was 204, 221, 293, 339, and 713. My understanding is that's been cleared up. I've also spoken with my court reporter. All of those exhibits have been admitted. Is that right, Kathy? Okay. So do you disagree, defense? I do not. Okay. So that means that all of the exhibits that I have as admitted, let me double check these here. All right, prosecution, what's your plan today?
Well, first of all, thank you for letting us do that exhibit audit to make sure that we had admitted everything. Our plan is, as soon as we bring the jury in, based on having that conformity between what we believe we had admitted and now what the court understands that we've also admitted with no objection from defense, we'll plan to rest as soon as the jury comes in.
Okay. Who are you calling first? Oh, sure. Hold on just a second.
So they're asking to approach. Leticia's awfully perky today, as we can see. While they're talking to him, you can see her face on there. She's got the, I'm screwed face. And she seems like she's getting counseled by her attorney. And there seems to be some kind of issue with the internet here, skipping on the feed from them. So again, this is just a reminder to everybody that if this particular feed, this one right here that we're looking at with Letecia, and it goes down, it will not come back up until until a break, because they can't, part of the order is they cannot show the jury's face due to privacy. And so what they are going to do is, if this particular camera, they've been having some issues with it dropping, this camera may not come back up until a break. But so far, you know, they put that preface on the case prior to the lunch break. But we saw during the lunch break, we kept the feed up, that somebody was actively working on the issues, and we had no more problems yesterday afternoon. So it is my belief that we should be fine with the camera and everything like that. I'm surprised they've got her so far to the bottom of the camera. Look at that. They got more ceiling than they do of the defendant in this room. She's at the very bottom of the camera positioning. I'm not quite sure why that is. Usually we have more of a taken back look of the defendant's table, where we can usually see the box of tissue. We can usually see their computers, their actual table, and even underneath the table. We're not getting that view. It looks like somebody may have knocked the camera. There's not. So just FYI, what's going on and what we're anticipating, what we expect as this state rests. They may be talking about whether or not Letecia is going to take the stand in her own defense. The judge did warn her yesterday, or caution her yesterday, that he was going to be asking her, I believe it was on Wednesday or Thursday of last week. No, it was Wednesday of last week. The judge read to her his requirement under the law, basically telling her that it was her right and her right alone whether she was going to take the stand, that she has a right to remain silent in her defense, but she also has the right to take the stand if she so chose. And he also told her not to answer that for him right then, that he wanted to make sure she had that time as well as the weekend to prepare herself and decide for herself whether or not she is going to take the stand in her own defense. He told everybody yesterday, after the jury had left for the evening, that he plans on asking her, and he's going to be asking her today or tomorrow, whether she's going to be taking the stand in her own defense. So this might be some type of negotiation. We hear a lot of times, even though everybody knows the rules of someone taking the stand in their own defense, but it's fair game. They're opening themselves up to being questioned literally on a litany of topics. So you find defense counsel always tries to limit the scope in what they can ask or discuss. And, you know, it's always told by, you know, the judge, you know what you're getting yourself into before you get into it. So I don't know if that's the conversation, but hopefully we'll find out.
Let's go ahead and bring the jury in then.
Nice to see you, Uncle Mike. Jennifer Kay, nice to see you as well. I am Team Summer. Good morning. My coffee beans are in the house, and we look like we're brewing just fine.
I should have asked. We do have everybody, right? Okay.
I'm putting a poll in now, right now. So
You guys
guys,
do return time of 1 o'clock. All rise for the jury, please. 1 o'clock, will that work?
we're taking a poll, guys. Hold on, I'm getting it ready now. Oh, this is the wrong one. Hold on. I want to poll. Start a poll. That's a yes or no question. There we go. All right.
Thank you. You may all be seated.
The poll is out.
Court will recall 20 CR 1358, People versus Letecia Stauch. Record should reflect the jury has returned to the courtroom. Good morning, ladies and gentlemen.
Morning.
It's a little better here today. Working on splitting that difference thing seems to be helping out a little bit. Let's hope it stays that way. Again, has anything occurred since we were last together that causes any of you to believe you could not continue
For
to
those that are
serve as a fair
just
and impartial
tuning in,
juror
if
in
you
this
guys have
case?
not given me a
If so,
thumbs up
please raise
yet,
your hand.
please consider giving me a thumbs up as
No
you
response?
roll up into
All right.
the house.
With that, when we took our break yesterday, we were still in the midst of the prosecution's case in chief. Mr. Allen, call your next witness, please.
Thank you, Your Honor. With Kevin Clark's testimony yesterday, that concludes the state's evidence, and so we would rest our case at this time.
All right, ladies and gentlemen, what that means is the prosecution has presented all of the evidence which it has decided to present in this case to prove all of the charges against the defendant beyond a reasonable doubt. At this point in time, the defense has the opportunity, but not an obligation, to call witnesses. I want to remind you that the defense does not have to present any evidence or call any witnesses. With that, does the defense have any witnesses it intends to call?
Defense has the right to remain
All
silent.
right. Do we know who?
See, they knew this was coming, and for them to drag their butts like this.
All right.
Get it together, defense. Get it together.
Dr. Niederhauser, if you would step forward and raise your right hand, please, ma'am. Come a little closer.
Oh, just go right there.
Sure.
It's okay. Do you swear or affirm the testimony about to give in this matter will be the truth, the whole truth, and nothing but the truth? Go ahead and have a seat in the witness stand. Please watch your step as you step into the stand.
Good morning.
Good morning.
Could you please state your full name and spell your last name for
Sure.
the court reporter who's seated right in front of you?
It's Rhonda, Ronda. And you need my middle name too?
Last name's
Okay. Niederhauser, Niederhauser.
How are you employed?
So I work at Fort Carson. I work at Evans Army Medical Hospital, and I work in Ivy Medical Clinic. It's a primary care clinic office.
Okay.
And I'm a clinical psychologist.
Okay. And what is your education?
I have a doctorate degree, PhD in clinical psychology, and then I have a postdoctoral master's in clinical psychopharmacology.
Okay. And is this your full-time job at Evans Hospital on Fort Carson?
Yes, sir, it is.
Okay. And you work at a primary care clinic?
I do, yes.
Okay. Do you exclusively or primarily treat people that have had mental health or
I see
mental
all
condition?
kinds of different things. I would say
Here
the
we go,
primary is
guys.
people with depression, anxiety, adjustment disorder. I work mostly with the dependents of military spouse or military service people. And then I work with veterans and their family members as well.
You do active duty soldiers as well?
Occasionally, our clinic is primarily for the dependents, veterans
Okay.
and their dependents. Yeah.
All right.
Occasionally, there'll be a mom that brings her kid in and has some postpartum depression or anxiety, and I'll see them. But we have other clinics that will take care of the active duty service members.
How long have you been at Evans Hospital?
10 years.
10 years. And how long have you been a practicing clinical psychologist?
Since 2000.
2000.
23 years.
All right. So
Clinical psychologist. not
in
forensic
December of
psychologist.
2019, did you meet with a Letecia Stauch?
Yes, I did.
Okay. And is this Ms. Stauch seated at the table, as you recall?
Yes, it is.
Okay. And what day did you meet with her?
I don't have that.
Okay.
But from memory, based on the records I reviewed, I think it's December 5th and also December 13th.
Okay. All right. And what did you meet with her about?
So she came in to see
year?
her primary care doc first, and that's kind of what I do. I'm a clinical psychologist, but I work as a behavioral health consultant. So my job is to work with the primary care docs to see what care somebody may need. So do they just need brief intervention? Do they need ongoing counseling? Do they just need medications? Kind of get them to the right place. So she originally came in to see her primary care doc. She was having some constipation, and the doc also did a depression and anxiety screener on her. And based on her anxiety symptoms and what she was going through with stress, her doctor walked her into me. And I have 30-minute appointments. I don't do the typical psychologist type of job because I work in a primary care clinic office and I get people walked in all the time. So she was walked in for me for stressors with her work, and she was having some anxiety symptoms.
Okay. So she went to see her primary care doctor back in December 2019.
Correct.
And your understanding is the primary care doctor thought that it would benefit her to come and meet with you, a clinical psychologist.
That's correct.
Okay. And how long did you talk to Ms. Stauch? Was it the full 30 minutes? Or
I documented it was 30 minutes. I didn't have a timer on it, and I can't tell from 4 years ago. So I'm sorry.
okay. And what was your diagnosis, or did you make a diagnosis?
It was anxiety, generalized anxiety disorder.
Okay. Did you prescribe any medication or treatment or therapy for her?
So I don't prescribe, so I make recommendations to the primary care docs. And then I recommended that she see a therapist.
Okay. What was your recommendation for medication?
Hydroxyzine.
Hydroxyzine?
She had said that she had tried other medications in the past, and she wasn't having depressive symptoms. It was more anxiety, and she was having trouble sleeping. And hydroxyzine is an antihistamine. It's like Benadryl. It's what you can get over the counter, which is in Tylenol PM, that can make people sleepy. But Benadryl's never been a medication that helps people with anxiety. Hydroxyzine, we found, can help with anxiety and can help with sleep.
Okay.
And that's what I had recommended.
Was she ever prescribed lorazepam by you or anybody else that you're aware of?
I don't remember.
Okay. Did you discuss stress and anxiety that she was having from her work as a teacher?
Yes. So she had told me that somebody at her work was being harassed, and that she stood up for that person. I don't know what kind of witness she was to them, but because she was a witness, she felt like she was being harassed.
Okay. And at some point, you provided a letter dated December 5th, 2019. There's also a letter dated December 15th, 2019, that has your name and everything, but there's not actually a signature. Do you recall that letter?
I do. Do you want me to speak to both letters?
No, just the latter one.
Yeah. The second letter, so I saw Ms. Stauch on the 13th of December. And at that time, she was doing better. She had decided that she was going to quit that job, and she was going to go in another school district. She was going to look for a teaching job in another school district. And because she had made that decision, I think some of her anxiety was relieved. In fact, when I did it's called a behavioral health measure 20. So it measures all kinds of different things, including anxiety. Her symptoms had gone down. And I think that was mainly because of making that decision to leave that job. So she left, and then I got an email from her that she apparently had talked to her work, her boss, whatever the case may be. And they told her that they wouldn't allow her to quit because she was on a contract. And if she wanted to resign, she'd have to have a letter from her doctor indicating that it was recommended. And so that was the letter that I had written, was that I recommended that she be able to resign from her position based on her anxiety symptoms.
Okay.
And then I sent the letter. I'll finish.
Oh, I'm sorry. And you had
Wait. Let's stop both of them. I know it's hard for you because everybody comes in, number one, they're nervous.
Sure.
And they may not have done this before, but the court reporter is taking down everything we say as we say it.
Sure.
That's important for one thing. It's easier for her to take things down if only one of you is talking at a time. It's also easier if you speak slower.
Okay.
She'll appreciate that.
Okay.
So let's try again.
And you provided Ms. Stauch a copy of the letter where you recommended that she step down from her current teaching position.
Correct.
Okay. Did you provide that a written copy to her? Or did you send it via text, electronic, email?
I sent it by email. I sent her a draft of the letter,
Okay.
which means basically I didn't sign it. I sent her the draft so she would be able to read it and see if she felt like it was sufficient, if I was not putting in too much information or if I was putting in not enough information. So I sent that letter, the draft of the letter to her.
The therapy that you recommended that she start, what type of therapy are we talking about?
It just would have been individual
Talk therapy
Yes.
with a psychologist or psychiatrist?
therapist, yes.
Okay. After December 2019, did you have any more contact with Ms. Stauch?
No, I did not.
Okay. Can I have just a second, Your Honor?
You may.
That's all I had. Thank you, doctor.
Cross-examination.
Thank you, Ron.
I apologize, everybody. I'm nervous.
Would it surprise you you're not the first person that's been nervous on the witness stand?
I was hoping I wasn't the only one.
Everybody feels it. Don't worry
Okay,
about it.
okay.
So Dr. Niederhauser, I think you said you've been a clinical psychologist since 2000. Is that right?
That's correct.
When you see a patient like you did with this particular defendant, what kind of things do you have access to?
Their report, of course, we do scales. We do a depression scale, which is called the Patient Health Questionnaire 9, and it gets the main symptoms of depression. We also do what's called a generalized anxiety disorder questionnaire. It's called a GAD-7. And so we have access to that, to give that to people. The second appointment, we do a behavioral health measure 20. The only reason that they did that one is the first one was with her PCM, and the primary care docs provide those questionnaires. I'll also provide it if the docs have not provided it, if they walk in to see me. But the behavioral health measure, when somebody has official appointment with me, they're filling that out in the waiting room, and then they bring it to me. That's what the government wants me, the military wants me to have people fill out. I'd like the other two forms better, but that's what they have us fill out.
Government and the regulations, right?
Yes, yes, military, yes,
Do you get a description of symptoms from the patient?
I do.
You agree that this particular patient, the defendant, endorsed that she had sleeping problems,
I do,
that she was feeling tired,
yes.
that she was having trouble concentrating,
Yes, I believe so.
and that she had moderate level of anxiety.
That's correct.
And then that she also, though, denied any suicidal ideation.
That's correct.
What does suicidal ideation mean?
Where she wants to kill herself.
She also denied any homicidal ideation.
That's correct.
She denied any intent or plan to commit either suicide or homicide as well.
That's correct.
And that was on December 5th, correct?
Correct.
Did that hold true on the second date, on December 13th?
It did.
She cited as the factors of her psychological issues as the stress at work, correct?
That's correct.
And that she was trying to quit that job,
That's correct.
and that she wanted a letter from you to be able to quit that job.
That's correct.
Did you consider the option that she might be manipulating her visit with you to get a letter to present to work?
I did not. That's not typically how we
Okay.
operate. We trust the people that come in to see us. I would not be a good psychologist if I cross-examined every person that came in
Sure.
and said, I don't believe you. So that's how a therapeutic relationship works, is you have to trust the person that's coming in to talk to you.
Did you note in your notes on this from December 5th that there was no disorientation observed?
That's correct. She knew where she was, who she was,
Why is that important?
situation. It's important because you have to know who you are, where you're at, what's going on.
And she had no problems there.
No, not at all.
She also was not exhibiting any hallucinations, correct?
That's correct.
Her memory was not impaired.
That's correct.
Even remote memory was not impaired.
Correct.
And more significantly, recent memory was not impaired.
That's correct.
Judgment was also not impaired.
That's correct.
Speech was normal.
Correct.
Rate of speech was normal.
Correct.
Didn't seem to be pressured in her speech.
Correct.
Tone was not abnormal. It was not monotone or any other abnormality.
Correct.
And volume was normal.
Yes.
And in fact, you noted no language abnormalities were demonstrated at all.
That's correct.
You also went through her thought processes, correct?
Correct.
They were not impaired.
Correct.
In fact, you noted that they were linear, logical, and goal-directed, correct?
Correct.
You also evaluated her for connectedness, correct?
I'm sorry, what?
Connectedness. Do you remember that?
I don't know what.
Okay, there's a note in your report that said evaluation of connectedness showed no deficiency.
Correct.
What does that mean?
So I think what you're referring to, and this has been like an old note, so I don't have access to it. But I think that it refers to how you connect to other people. And I didn't see any problems with her connecting to me. And she had connections to other people, her family.
Okay. And just so you're aware, I know that you're nervous. It's okay to be nervous, like I was talking about at the beginning. If you can't remember, and it would be helpful for you to review your report. If you tell me that you can't remember and it would be helpful, I can show you your report
Okay.
and then you can review it, okay?
Okay.
That's a standard thing that we do with lots of witnesses.
Sure.
You noted that her insight was intact.
Right.
What does that mean, insight being intact?
She recognizes what's going on with her. She has insight that she has anxiety, that kind of thing.
And you also noted that she was not having any delusions.
Correct.
If you're noting all of those things, are those signs that somebody is not suffering from a severe mental health disorder?
That's-
We approach.
No, if you have an objection, state it.
Honor, I don't believe this witness is allowed to.
It's their witness.
Then she can tell me if that's the case.
And what I'm asking Dr. Niederhauser is, based on your years of experience as a clinical psychologist since 2000, and then working as a clinical psychologist for Evans Army Hospital and at Fort Carson's, are those types of things that somebody would suffer if they are suffering from a severe mental health disorder?
Can I answer that or no?
I'm not the one giving direction here.
Okay. So what I basically would say is if I had any concerns that she was a danger to herself, a danger to someone else, or she was gravely disabled, which means she was psychotic or so severely depressed that she wasn't functioning, then I would have placed her on a 72-hour hold and sent her to a psych hospital. So she had some anxiety, she was having some stress, but she was not suffering from severe mental health disorder to the point where I felt she was a danger to herself or others or couldn't function.
Okay.
Or was psychotic.
Drop the mic.
Okay. And that's exactly what I was asking. This particular patient was not suffering at the time that you saw her in December on the 5th or the 13th of any severe mental health disorders, correct?
That's correct.
In fact, you noted that she was only suffering from generalized anxiety disorder.
Correct.
What is generalized anxiety disorder?
So that's where you have anxiety, and for people that aren't familiar with anxiety, it's just worry, nervousness, like I am right now. And so you worry about everything. So you don't just worry about certain things, you worry about a lot of things.
Okay.
Well, their first witness ended up being a dud.
On December 13th, you went through the same sort of neurological assessment of the defendant, correct?
Correct.
You noted that there was no disorientation observed,
Correct.
that she was oriented to place, person, time, and situation,
Correct.
that she was not suffering from any hallucinations,
That's correct.
that her memory was unimpaired,
That's correct.
and that remote memory was not impaired,
Correct.
recent memory also not impaired,
Correct.
judgment was not impaired.
Correct.
Why is it important to note that her judgment was not impaired?
Because if somebody has poor judgment, then they're going to make bad decisions.
And her judgment was normal.
Correct.
Her speech was normal.
Correct.
Tone again was appropriate. No volume issues or monotone issues or anything like that, correct?
Correct.
And when I mean a dud, I mean she helped the prosecution more than she helped the defense. She just sunk Letecia's boat. This
And
was
then you
one
noted on that same day, December 15th, that last time that you had evaluation with this defendant, that she was still only suffering from generalized anxiety disorder.
Correct.
You mentioned the M1 hold, that 72-hour hold. Tell the jury what that is.
So it's a hold that I can place on somebody and send them to a psych hospital. It's up to 72 hours. Generally, when you send them to the psych hospital, the psychiatrist or whoever's in charge at the hospital will continue to keep them on that hold. The reason we place somebody on a 72-hour hold is because they're a danger to themselves, they're a danger to someone else, or they're gravely disabled, like I was saying before. So they're so psychotic that they don't know who they are, what they're doing, or some people are so severely depressed that they're not eating, they're not taking care of themselves, they're not functioning. So that's where we can place somebody on it's called an M1 hold in the state of Colorado.
And during your career as a clinical psychologist, have you ever dealt with somebody that you had to put on an M1 hold?
So since I've been at Fort Carson working in a primary care clinic office, I don't see it as often, but I would say probably in the 10 years I've been doing this, it's probably been once or twice a year. So it's not frequent, but it happens. Prior to this, my job was as a mental health evaluator at Memorial Hospital for 5 years. And that's exactly what I did. People would be brought into the emergency room to make a determination if they were a danger to themselves or others or gravely disabled. And so I put people on M1 holds or emergency commitments. Emergency commitment is same thing, except you're under the influence of alcohol or drugs. And the emergency commitment, you would send them to detox, and that's a 5-day hold. And so I had a lot of experience of working in emergency situations and placing people on M1 holds or emergency commitments prior to working at Evans for 10 years.
As a professional and as an expert in clinical psychology, do you feel comfortable doing that if you're seeing the signs that would be appropriate for a placement on an M1 hold?
Yes.
Did you see anything about this defendant on either December dates of 2019 that caused you to have any concern that she was a danger to herself or to anyone else?
No, I did not.
Okay. May I have just 1 minute? Your Honor?
You may.
What was the source of information as it relates to your interactions with this defendant?
Just the clinical interview with her and the scales that we utilized.
So basically everything coming directly from her.
Correct.
The
only time we get collateral information is if we do have concerns about somebody being a danger to themselves or others, or they're psychotic, or people are worried about them because they're not functioning. That's when I would get collateral information from other people.
And that didn't occur here?
No, it did not.
Okay. Did she have any history whatsoever of psychological treatment in the past?
She had told me that she'd been diagnosed with anxiety in the past. In her medical records, she does have a diagnosis of panic attacks and anxiety. And then she had told me that she had tried different medications, but I don't think she'd ever seen a therapist before.
Was there ever any history that you knew of that she'd been in an inpatient treatment?
She had not.
Had not?
Had not. That's at least what she told me.
She told you that?
Yes.
Okay. Did she mention any, as it relates to the stress or the anxiety, did she mention anything to you about stress related to her stepfather from 20 years ago?
She did not.
Did she mention any stress related to sexual abuse at the hands of stepfather from 20 years ago?
She did not.
Okay, thank you. That's all I have, Your Honor.
Redirect.
I don't have any questions. Thank you. Thank you.
Do any of the jurors have any questions for Dr. Niederhauser? Looks like we have one. Counsel would retrieve that, and counsel approach, please.
That was damning right there. Thank you, Julie. God bless you. This was literally a month or so before, because she saw the doctor December 5th for the first time, again on December 13th, and had her write a letter on December 15th. And Gannon disappeared on January 27th. So if she was having psychosis or anything like that, it would be going on at this point. And she's noting that there's no severe mental illness. There's no, this is stress from work. This is generalized anxiety. We'll get back to this.
Dr. Niederhauser, did you or the defendant set the second appointment on December 13th?
I did.
All right.
Well, I asked her to get an appointment and somebody scheduled it.
Okay. I will allow reasonable follow-up as to that question only. Mr. Cook? Mr. Allen?
So how was it that you had contact with her to set that second appointment?
So usually what I do is I walk them out. There's a back desk, they check out, and then they actually make an appointment. So I think that's how it happened.
Okay. So it's basically at the end of the first appointment, you walk out to the lobby and then you say, set another appointment in a couple of weeks, essentially.
That's correct.
And why did you have to do that for this particular person?
I typically do that as just a normal routine because I want to make sure that I don't do the ongoing therapy, but I want to make sure that I'm following up with patients and making sure that they're getting the help that they need. And so that's why I set it up. And then she did get prescribed that hydroxyzine. And so I wanted to follow up with her and make sure that how she was doing on that medication.
So this was only in response to just you wanting to make sure that what you were recommending was working and to follow up, not because you had some concerns about severe mental health disorder.
That's correct.
Okay, that's all I have. Thank you.
All right. Thank you, Dr. Niederhauser. You may step down. All right, ladies and gentlemen, before you came in this morning, the attorneys and I were talking about some logistical things. And I know you might not be surprised. You might be, but you might not be surprised to find that in a case with this number of witnesses, this number of exhibits, sometimes scheduling issues occur. And so we don't have any other witnesses until 1:30. Until 1 o'clock. We're having there's a scheduling issue with respect to the next witness. So what we're going to do is I'm going to send you out until 1 o'clock. If I can have you back in the jury room at 1 o'clock. Again, don't discuss the case with anyone else. Don't discuss the case among yourselves. Don't do your own independent research about any aspect of this case. And the attorneys and I will be dealing with other issues. We're going to talk some probably about some jury instructions, some logistical things and things like that. So while we're not able to use your time efficiently this morning, I still hope to do that here. And we are still ahead of where we thought we would be at this point in time. So I know it looks like there's some downtime, but we're still going to use it efficiently from our end. And we are still ahead of where we thought we would be. So enjoy the morning, I guess. And we will see you at 1 o'clock. All rise for the jury, please.
We'll see what's going on here. We're gonna, if they're just gonna do stuff. Their witness, the one witness that they had, ended up being a great witness for the state. I'm just like, they're not gonna win. They're just not gonna win.
Thank you. You may all be seated. Record should reflect the jury has left the courtroom. All right, Ms. Stauch, I'm going to go back through some of the questions that I talked to you about last week. I just want to confirm prosecution, there are no prior felony convictions. Is that accurate?
Correct, Judge. There were some prior felony arrests, but they were not convictions.
Okay. All right. And Ms. Stauch, how old are you? And we've talked a little bit about your education. You have a bachelor's degree, a master's degree, and a doctorate degree. Do I have that right? And how's your health today? And are you now or have you been under the influence of any alcohol or drugs in the past 24 hours? Do you understand that you have a right not to testify? Can you hear her okay, Kathy? Okay. And if you choose not to testify, then the jury can be instructed about that right and be told that they cannot infer your guilt from the fact that you remain silent, and that it would still be the prosecution's burden to prove the elements of the case to the jury beyond a reasonable doubt. Do you understand that? Do you understand, however, that you have a right to testify? And do you understand that if you want to testify, no one can prevent you from doing so? Do Do you understand that if you choose to testify, you may be cross-examined by the prosecution concerning any matters which are relevant and material to this case? Do you further understand that juror questions may be submitted, but that the same rules of law, evidence, and procedure that apply to lawyer questions will apply to juror questions, and that improper juror questions will not be permitted? However, legally proper juror questions may be asked of you if you decide to testify. Do you also understand that the decision to testify or not to testify is yours personally, and only you can make that decision? Do you further understand that even though your attorneys may disagree with your decision, that the decision is entirely yours and yours alone? Do you fully understand this advisement? Is there anything further you wish for me to explain to you concerning your right to testify or not testify?
God
What
bless
is your
you,
decision?
Julie. Thank you so
You wish to
much. Just
testify or
gifted
not
5
testify?
memberships. Tell her thank you if you received one of her memberships. Thank you. Thank you.
All right. We'll wait until Dr. Lewis has concluded her testimony, and we will see where we are then. And we'll go from there. In the meantime, let's use a little bit of the time for jury instructions, just preliminarily. I'm going to take out the instruction regarding discrediting by conviction of a felony. We've not had anybody. The instruction regarding expert, I think, is missing some language. I have to look at it. It looks like it's missing some language, so I just need to look at it. And then, Mr. Tellini, do you have a theory of defense? Are you intending to submit one? Okay, so, all right. And do you have any objections to the instructions that have been tendered by the prosecution?
The only one I have, they all appear directly with Bold G, except the one about lay witnesses.
Right.
On sanity. The objection to that one, I understand it comes from statute, but I think it unnecessarily highlights that testimony. I mean, clearly witnesses can do that. The court, clearly allowed them to do it. So I think it's implied that it's acceptable for them to do that instead of the research.
Mr. Allen? Mr. Young?
Yes, good morning, Your Honor. Not prepared to give you case law on this particular issue this time, so I'd like to reserve argument until I find the case that addresses this issue.
Okay.
Obviously, there's a statute right on point that allows that to happen, which is 16.8.109. The jury has heard that type of testimony. Defense has objected in front of the jury to that type of testimony. Therefore, the people feel it's necessary to give them an instruction as law with regards to layperson testimony. The wording of that instruction is, I believe I used that particular instruction in another homicide case where insanity was an issue. I just can't recall what case I got that from. And so I'll be able to get that to the court this afternoon.
Okay.
Of course, the defense has an alternative instruction that they'd like to provide. We're more than welcome to look at it.
Well, I'm looking at 16.8.109. This issue came up earlier, I think, in response to Mr. Grusing's testimony. Okay. All right. All right. And Ms. Stauch, as I understand it, you're willing to waive your presence for the jury instruction conference? Okay.
How much of that you heard, but I didn't realize my mic was turned off. But it appears that she's being arrested. She does not want to be there for the jury instruction conversation or debate between the attorneys and is asked to leave. So she's going to leave while they have these conversations.
All right.
And now she's gone.
I'm looking at 16.8.109, and as I was about to say, I think that the instruction as submitted, I'm not sure I'm going to give it in the form that it's in light of, get the citation for you here. I know the case of People
Excuse
versus
me.
Dunlap,
I'll
but I
turn the
can't
mic
remember
off.
the citation offhand.
Got 173 P. Does it sound right? Dunlap?
Nope, I'm thinking it's 36 P third 778. And the case that I'm thinking about now, granted, there are a number of different iterations of Dunlap because it's a death penalty case, so it went up and back a number of times. But I think the case that I'm looking at is 36 Pacific 3rd 778. I can tell you for sure the principle of law is that it was reversed because the language in the instruction that was given by the court did not specifically track the language in the death penalty statute. And so I think the closer that language in an instruction tracks the actual language in the statute, I think the better we are. I do think, and I am inclined to give such an instruction in part because it's warranted by the law, and in part because there has been some testimony regarding from lay witnesses regarding their impressions about Ms. Stauch's mental status at any particular time. And so I think that the jury should be advised that they can, whether they give way to that or not is up to them, but I think that they should be advised that it's proper to consider that and take that into consideration. And then the only other question that I had was you submitted a jury instruction that I didn't know what the source was. It says the question of the defendant's sanity or insanity has reference to her mental condition at the time of the alleged acts, the condition of the defendant's mind previous to the act charged and since that time may be considered only to aid you in determining her sanity or insanity at the time of the acts charged. It sounds like it's a standard instruction somewhere, but I didn't find it.
Get it. I did these so long ago, it's hard to remember where I got.
Okay.
I got most of them from Colgy, but I also did some from prior cases that I had. So I'll do some research while we have some time and figure out where I came up.
Okay, that one, that's the only one that I had the question about. So, and let's see. is there anything else that we need to address prior to Dr. Lewis's testimony at 1 o'clock? Mr. Young?
Besides what we talked about yesterday, that's the only concern I have.
Well, let's talk about that because she's going to be here at 1 o'clock. So what is it that you are requesting?
That the court remind her that she's not to get into the substance of her meeting on Sunday for 3 hours with the defendant and.
Okay. All right. Okay. Mr. Tellini?
She does in the evaluation diagnose with a possible traumatic brain injury in reference to early hospitalizations in the report that was provided before.
Can you show me where that was?
Yeah.
That's in there. I just remember reading that as well.
I remember reading it. I just can't remember which report, whether it was hers or someone else's. I didn't recall it as I was looking at it in hers. So what page are you looking at, Mr. Tilley? I see the diagnosis of the traumatic brain injury by history, but I didn't see where she mentioned. Yesterday, we were talking about a softball incident, and I didn't see that mentioned. Okay. No, not well, 1 o'clock.
Okay, because they're confused on the 11.
Yeah, no, 1 o'clock, because that's when Dr. Lewis will be here.
Yeah.
1 o'clock is 3 o'clock
yeah,
our
don't take it
time,
back
so
to
you're
CJC.
talking quite a bit of time here.
Yeah, so on the preliminary report.
The preliminary, okay.
Yes, on the third page. Talked about a second diagnosis could be partial seizure. These kinds of seizures are characterized by auras. She was severely injured when a shell fell on her head and knocked her unconscious. Prior to that, she suffered a head injury and was taken to the emergency room for a CAT scan and had a discharge of diagnosis.
Okay. Mr. Young?
It wasn't about a softball, obviously, injury. It's in her report that may lead to this conclusion that she comes up.
Okay.
And I do recall her talking to Ms. Stauch about the bookcase during her forensic interview that was recorded back in.
Okay. I think she can talk about that. Again, she can't talk about a softball injury other than to say that what she says here, prior to that, she suffered a head injury, was taken to an emergency room, required a CAT scan, and had a discharge diagnosis of brain damage. I think she can talk about that. What? Oh, she wants to come back. She can. Other than that, is there anything else that we need to take up?
Nothing from the
Defense? Okay. All right. We'll see everybody at 1 o'clock then. And I will tell you that even if we finish early today, we're not going to do closings tomorrow. I think it's fair to give everybody some time to get things together. So the earliest that I would anticipate closings would be Friday. I just think everybody needs to have some time to put all of their thoughts together. So, all right. We'll be in recess then.
I actually thought they killed the camera because she was about to come into the courtroom and they weren't quite done. But I looked at the time when they were talking and it's like, you know, they're not coming back until 1 o'clock. And I'm like adding 2, that's like 3 o'clock this afternoon. Like we got like 3 hours to fill. So I honestly don't know how we're going to fill 3 hours of me talking. I'm not that interesting. I'm not that interesting. So what we'll do. So I'm trying to decide right now. There's going to be there's a video that's just about to be released. I did it this morning, and I scheduled it for noon because I figured we'd all be here, you know, watching, and then by our break at noon, which would have been 2 o'clock their time, I was going to be playing the video that I prepared that dropped at noon our time. about the Alec Murdaugh case. And so I was going to give you guys a sneak peek of it before anybody else sees it, because it's going to be dropping in 12 minutes. So that's what I'm going to do first. I'm going to give you guys a sneak peek. Well, actually, it's not really a sneak peek. It's the whole thing before anybody else gets to see it. And I hope you like it. I worked on it. I worked a little harder on it. I did a little different intro for it. I did a different intro for it. It's kind of same song, just different intro. And a different, because I like, oh, I got to go into my studio. I'm like, where is it? It's not here. Because it hasn't dropped yet. So we get to go into the studio. The backside, because it hasn't dropped yet. Durr. Okay. Hopefully it doesn't auto start, and it does auto start. So here we go. This one. Here we go. Here. Okay, guys, you guys get to watch this first. It's going to be dropping. It's going to be dropping in like, 10 minutes now. It's going to be dropping as soon as it wraps up because it's 9 minutes long. So, hey guys, many of you know I have been following the Alec Murdaugh case very closely, and this is in Low Country, South Carolina. This is a case of a prominent South Carolina attorney stealing from his clients, killing his wife and son, and then attempting this suicide plot against himself, just all foiled and blew up in his face. If you're not familiar with the Alec Murdaugh case or situation, here's kind of a brief rundown of events. In 2015, a boy by the name of Stephen Smith was found in the middle of the road from what apparent hit and run accident. His mother never, ever, ever believed for 1 minute that her son was hit by a car. Something else was going on. The Murdaugh family was named over 40 times during the initial investigation. Although the case was ruled an accident, it has been reopened and Stephen Smith's body has been exhumed. In 2018, Gloria Satterfield, a longtime housekeeper of the Murdaughs, suddenly tripped in their home, apparently. And she was taken to the hospital where she later died sometime later after this apparent fall in this house. Alec Murdaugh talked to her sons. Again, they were like family, been in the family for about 30 years. Gloria was inside their home and an employee of theirs, a very long relationship with Gloria Satterfield, and the boys knew her because she was their nanny at one moment in time. She's now dead, and Alec reaches out to her sons and says that he's going to sue himself, and this was all concocted. Long story short, Alec Murdaugh was successful in the lawsuit against himself with the help of another friend attorney. However, the boys never received any of those funds. Alec Murdaugh stole that money from them unbeknownst to them, along with hundreds of other clients of his that he stole money from. He currently has 20 indictments and over 100 financial crime charges currently against him right now that still need to be adjudicated. However, in 2019, his son Paul took a boat out and got drunk and ended up killing a young lady by the name of Mallory Beach.
This is the person that lost their life in the boating accident,
which set off this chain reaction of events that was about to expose Alec Murdaugh's financial crimes. It was getting very close to a motion to compel in that civil action against Alec Murdaugh and Paul Murdaugh for the death of Mallory Beach. Then in 2020, shortly after him receiving the motion to compel, his wife and son were brutally murdered on their property in Moselle. Alec Murdaugh went to trial for that case, and he lost his trial and was convicted of a double homicide, and his sentence was life in prison. Now we're finding out, and also through the trial of Alec Murdaugh in the murder case, one of the Satterfield sons spoke as a witness for the state in what happened to him and how Alec conned him out of so much money unbeknownst to him. The lawsuit between the Satterfield boys and the law firm that Alec worked for ended up settling with them for $6 million. And now we're learning that it is possible that the Satterfield boys will have to pay that money back. Take a look at this tweet from on Twitter. OMG. This would be absolutely terrible. This morning I'm looking here on Twitter, and this is a tweet from Sarah. It says, breaking news on Alec Murdaugh. In his answer to an amended complaint in a lawsuit by Nautilus, which is the insurance company that paid the settlement, the Satterfield settlement against Murdaugh and co-defendants, Murdaugh admits that Gloria Satterfield was not pushed down the stairs by the Murdaugh dogs. This essentially makes the insurance claim fraudulent and the death ineligible for settlement monies paid to the Satterfield sons via their lawyer. Cause for concern, ? The settlement monies may have to be paid back by the Satterfield sons and their attorneys. What do you make of this? Defendant admits to allegations 17A and 17B. No dogs were involved in the fall of Gloria Satterfield on February 2nd, 2018. After Miss Satterfield's death, defendant invested Miss Satterfield purported statement that the dogs caused her fall to force his insurance to make a settlement payment, and he stated that she was not on the property to perform work. What do you think of that? What do you make of that? Is that wrong? And do we really believe Alec Murdaugh? Alec Murdaugh is one of those compulsive liars. He knows that the Satterfield boys did damage at his trial. Is this a way for him to kind of get back at the boys? Is this a joke? Did this happen? Is it possible that Alec Murdaugh himself pushed her down the stairs? So a lot is going on in this case. I'm almost sickened for the Satterfield boys right now to even be thinking that it is possible that any of this money has to be paid back at the word of Alec Murdaugh, because he says in a statement that this didn't happen or that didn't happen. This man has been proven to be a compulsive liar. Do we believe him in this response? Let me know your thoughts. Don't forget to like, share, and subscribe to the Bullhorn Betty channel. And until next time, please be safe and kind to one another. God bless you. There you have it. They ended the webinar too. Let me stop sharing. They ended the webinar too because it's going to be such a long pause that we're going to have to sign back in later today. There you go. That should be dropping right now as we speak. Well, about a minute in there. So don't forget to watch it again. Give it a thumbs up, okay? But you guys were special. I didn't do it this morning when we have a lot more people in the chat, because obviously I want you guys to watch it. So but I hope you guys like it. I decided to do kind of the same because I know people say that my intros are a little long, and that's okay. So I figured if the intros are about the topic of discussion, at least you guys will have something new to watch each and every time. And there you have it. So you guys got to see some of the behind the scenes stuff for the Alec Murdaugh trial while we were out there. You got to see him getting loaded up into that truck with handcuffs on, right? So hopefully you guys enjoyed it. Don't forget to pass it around, share my opinion with others. And I don't know. I think at this point it's going to be hard to sue the Satterfield boys because of what Alec has done to them. And not only that, but it's going to be hard to prove Alec's statement. I mean, short of the autopsy changing for Gloria Satterfield, or if Alec is charged with her murder, I don't see how they're going to have enough evidence to prove that she didn't fall down those stairs by the dogs. I mean, if those are the only way that I can see that would be probable. You know what I'm saying? So anyways, guys, I'm not going to stay on here until 3:00 this afternoon. I'm just not. We're going to have to do part 2. We're going to have to come back and do a part 2 of this, and we'll start it around 2:30 this afternoon. But I just don't, I have, not that I don't love you guys, but I could be doing some work because when I'm on my live, it jams up my computer. I can't do videos. I can't do anything. So I love you guys. It's been great. We've hung out for over 2 hours, which is our normal coffee club time. But I'd like to get to work. And not only that, we're going to be back here in 2 hours anyways. So you guys can live without me for 2 hours. Okay? I promise you. And as you noticed, I am kind of taking the weekends off here lately. I'm taking the weekends off here because I need some downtime. Typically I work a lot, but these trials lasting, because the time difference and stuff like that, anywhere over 8 hours where we're online just for 8 hours, it does wear on me, because I'm sitting here in this one chair. I'm not back in the office yet. So I'm still on this recliner, which wouldn't be too bad if I could kick back and, but I have to have the camera up here. So, and I got to be able to type and move stuff around. So I got to be able to have access to the computer. So I can't put the recline up. So it just does something to the back, So anyways, we'll be back here in 2 hours, and I will see you guys really, really soon. What else do we have going on here? So we did, before we go, the state did rest their case. We are now seeing the defense. Let's just give a little briefing while we're all here before we break, just in case I end up falling asleep and not waking up again. No, I'm just joking. I'm just joking. But their first witness on the stand was a clinical psychologist. This is a little bit further, like education wise, much lower than the expert forensic psychologists that were put on the stand by the state. She first met just, not a little over a month before Gannon was killed, because she was having some stresses at work. And so this particular clinical psychologist had treated her from some generalized anxiety. She saw her for the first time on December 5th. She had a follow-up appointment on December 13th. And then Letecia reaches out to her and asks her for a letter. But before she gets to the letter, after the December 5th visit, those findings were sent over to her general practitioner, which provided her a drug for generalized anxiety as hydroxyzine. And then on 12/15, Letecia decides that she needs a letter. On the 13th, when she visited with the doctor, she told her that she's feeling much better. She's decided to leave the school and start looking for another job in a different district. And then on the 15th, she ends up calling her doctor, or this psychologist, and says that her school is giving her a hard time, won't let her quit, says that she's under contract, and the only way they would let her out of the contract is if she gets a letter from her psychologist saying that she needs to leave the job due to this, that it's good for her health, anxiety, or whatever. But the state did reiterate that this was stress from home. There were no impairments whatsoever during these visits that she saw her. She noted that her thoughts were logical and she seemed to have logic. There were no issues connecting with people. She recognized, she was self-aware, no delusions, no, seeing of other people, no being a Maria Sanchez. There was no severe mental illness. Generalized anxiety disorder is what this doctor, stated that she was. She also noted on 12/13, in addition to all that I had just listed, she also said her judgment was not impaired. She said nothing about her stepfather, nothing about this alleged sexual abuse from her stepdad, none of that. This was just generalized anxiety from stresses from a school that she worked with. That's all she said. And so I just wanted to make sure that you guys knew that, because at the end of the day, she's not crazy. She wasn't crazy. When she killed Gannon, she knew what she was doing was wrong. She thought she was going to be able to get away with it with some creative planning, and she just was not smarter than a 5th grader. That's the problem. So anyways, we'll see you guys back at 2, and we'll be talking about Letecia. It sounds like this case is over this week. It sounds like, even if it doesn't sound like the defense has a whole lot of witnesses. This witness particular ended up being a better witness for the state than it did for the defense. I mean, they crumbled that witness up. They pretzeled that witness right up to the point. And not only that, but the defense had a missed opportunity, because they should have recrossed her after that lengthy redirect after that lengthy cross-examination from the state, because the state just demolished her. I mean, they didn't demolish her testimony. She was being truthful and correct. It's just that the whole purpose of her being there was to help the defense in showing that Letecia was mentally ill, and that didn't happen. As a matter of fact, it confirmed the information that the state has been trying to say, that she has not had any problems mentally, that she has not had a severe mental breakdown, that she has not had some crazy illusions and delusions and everything else. This witness ended up being a better witness for the state than it was for the defense. So usually when you start off like this, it's not going to get better. We saw this in the Alec Murdaugh trial. You're kind of expecting this witness to come up there and really show how crazy she was at the time that she killed this beautiful 11-year-old boy, and they're just not going to be able to do it. So We'll see how many witnesses they have, but it sounds like it's potential that their witnesses could be over today, because even the judge says we're not going to go into closing arguments tomorrow. Even if we get through everybody today, we're not going into closing arguments tomorrow. He said that the soonest they'll do closing arguments is Friday. So they're going to, and he says he's not going to time limit the closing arguments. Typically, he thinks an hour and a half per side should be more than enough, but he also said he's not going to prevent them from giving them a time limit, that they're more than welcome to take up as much time as they want, but just be prepared if it goes over that 90-minute mark, he may have to pause their closing to allow to give the jury a break. So I think that the closing arguments, I think both sides are going to be able to easily have closing arguments done by lunchtime on Friday, leaving the jury plenty of time to deliberate. I don't think this is going to be a tough deliberation for these jury members, what they had to endure and see, and how they saw Letecia's conduct inside that courtroom, and how so far the witnesses the defense have put forward aren't really helping her case. So those are the reasons why I believe that they're going to come to a quick verdict, and their quick verdict is she's guilty on all counts. That is my my theory right now. My opinion going into this thing. That's what I think is going to happen. That's my ESP. That's what I think is going to happen. But we'll see. All right, guys. I'll see you at 2 o'clock. 2:30ish. I'll see you right around that time, and we'll do part 2 and finish this day up. It doesn't sound like they're going to have a whole lot of witnesses to bring forward, and I think this case is pretty much done. And I can tell you, we already know what my opinion is. Hold on one real quick second before we leave. Last thing I forgot is to end the poll. 47 to 53. How many do you think, who do you think if she's going to take the stand or not? 52% said they don't believe Letecia will take the stand. 47% believes she is going to take the stand. So I'm going to call it as a 50-50 split between our audience. 50% believe that she's going to take the stand, and 50% believe she's not going to take the stand. So we're going to find out really soon whether or not Letecia is willing to sit in the hot seat and explain herself. We'll be back at 2.